Let's take this to its logical conclusion.
Okay, let's
using
do this.
the model
Yes.
that we have set up
Yes.
under the Supreme Court majority.
Yes.
The president does speak to the military. The military does control SEAL Team 6. So that in and of itself is inside the official act. However, the president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed.
He doesn't understand the ruling. He's making the mistake that to overcome the presumptive immunity, you have to show that the action was really bad. That's not the test. The test for overcoming presumptive immunity has nothing to do with how bad the act is. The test has to do with...
Then that would threaten the constitutional order.
Whoa! Yes! Yes! Holy sh**. These are my full takes on the recent Supreme Court case that was just ruled on July 1st, in which Donald Trump is bringing a case before the Supreme Court seeking some forms of immunity from criminal prosecution for at least things that he considered to be official acts of him as the president. That's what his counsel was arguing in front of the Supreme Court. A lot of people are talking about this, probably people who either haven't read it or don't understand it or have, some agenda that they're interested in pushing about it. But regardless, here's my reading of it, of which we've spent the last 3 days painfully going over the entire decision. Chief Justice John Roberts, writing their majority opinion, argues that the president has 3 different types of actions that he can take and then creates a novel ruling about the types of criminal immunity that would apply to the president based on the kind of action that he's taken. For these actions and for the criminal immunity that's been granted for these actions, this is a new thing that has never been done in the history of the United States, as far as I'm aware, as far as anybody else pointed out, for basically any citizen ever at any point in time. The idea that there would be absolute criminal immunity for some action has never been discussed in the history of the United States, not for the president or anybody else. Roberts is going to make a ton of citations to a case relating to, I think it's Nixon v. Fitzgerald or Fitzgerald v. Nixon, that has to do with suing the president for having an airline official being fired, basically. But despite the fact that Roberts will cite to this case over and over and over again, that case had to deal with civil immunity, meaning that a president can't be sued for civil damages. It had nothing to do with criminal immunity, and every mention of criminal immunity in that case seems to be judges all saying, like, obviously this wouldn't apply to criminal stuff as well. We're only talking about preventing the president from being sued for, by private citizens, civil matters, right? So the 3 buckets that John Roberts basically groups actions into we have core powers, which are actions that, and he's borrowing language here from a prior case, he calls these conclusive and preclusive actions that only the president can perform. Any action that's taken here is given absolute immunity. These actions are not only beyond judicial review, none of these acts are able to be cited or referenced in any other criminal matter as evidence or otherwise. So if Donald Trump is performing some action that we consider to be conclusively and preclusively within his role, so for instance, conversations between him and his officers, like the heads of his departments, these things would be beyond all criminal review. You can't probe into them. You can't cite them for anything else. So for instance, let's say that we knew that Trump said, I'm going to fire you unless you do XYZ criminal act. Let's say that I can't criminally indict him for that. I can't even use that as evidence towards another crime, which is going to be relevant for obviously for Trump's criminal prosecutions. But the core powers here that are conclusive and preclusive to the office of the presidency, Roberts has said that these are given absolute immunity from all criminal prosecution. I think if you go to destiny.gg/notes, I think you can get all my notes that I publish for things, and you can go and read. I've got larger quotes from the decision here, and I think I even have the decision in my document somewhere. But the second bucket that he's got, he calls these things official acts. So official acts are actions that the president takes up, that are up to the outer perimeter of all of the things that a president can do, as long as it relates to the effective discharge of a president's powers. So any action that's declared to be even in the outer perimeter of what a president might do as an official act are given presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. Roberts will speak a lot about how we need an energetic and vigorous executive, and he will cite to Federalist Papers when he says this over and over again. I will say, however, that if you read those Federalist Papers, what they're actually talking about is having a single head of the executive, as opposed to like a council or multiple people in an executive. I don't believe any of them were referring anywhere whatsoever to being immune from criminal prosecution. I think that if you just imagine historically how the United States was founded, the idea of creating an executive who was beyond criminal prosecution is kind of silly. Obviously, none of the framers had this in mind. That would be ridiculous. We just rebelled against a king. Why would we make another one? This means that the burden is on the government to argue that applying a criminal prohibition to that act, or I should say, I'm sorry, that engaging like a criminal investigation of that act, the government has to argue that that investigation would pose no dangers of intrusion on the authority and functions of the executive branch. There cannot be any danger whatsoever for the president to perform his job. So if you're doing an investigation, even if you think he might have done some criminal act, if that investigation risks damaging his ability to perform any other act, if you can't prove that there would be no risk there, that action is also given immunity. One thing that's important too when we think about this type of immunity that's being granted, this immunity is not like a defense that one would use in court, or it's not a defense that you would use on appeal. This is like a thing that comes before any court action has even happened, right? So we're not even in any part of the court stage. It's not like the president would go to court and would use this as an affirmative defense, like self-defense or something. This would be stuff that would completely prevent all of these things from ever even being showed in any trial or anything. Those are official acts. Then the third bucket are things called unofficial acts. These are actions that the president takes essentially as a private citizen. I mean, he could take these actions as president, but they're just unofficial acts. They have nothing to do with his job as president. And obviously, Roberts says that for unofficial acts, there is no immunity. Now, unfortunately, we are given absolutely no guidance nor examples for what a private act might be or an unofficial act might be. Roberts does not list a single one ever. Roberts notes that in dividing official from unofficial conduct, courts may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. So when you're doing investigations and you're trying to separate an official act from an unofficial act to figure out, was the president operating in his capacity here? For instance, let's say when he gives a speech, he could be acting an official act or unofficial. You cannot consider the president's motivations when you're trying to figure out whether or not this would fit the official or unofficial act. A lot of the people that are talking about this opinion are trying to say that, oh, well, you know, he only gets immunity for core powers. That's great. And unofficial acts obviously can still be indictable and can come under judicial review in the criminal justice system. But what all of them are skipping over is the idea that the official acts presumptive immunity could be unfathomably broad. And we've been given absolutely no indication by Roberts, by this court, what those official acts might be. Roberts will go on in his opinion to reference 4 different categories or sections of conduct that are in the indictments against Donald Trump, and he treats each of them as such. So conversations between Donald Trump and his acting attorney general with regards to sending fake letters. He essentially said, not essentially, he said, you need to send letters to states and you need to tell them that we have, good reason to believe that there's been voter fraud, that the department is investigating these things and we found evidence of it. He was telling his attorney general, you need to lie and send these letters. And if you don't, I'm going to fire you. Because this is under the exclusive role of the president, these are conclusive and preclusive powers. The president gets to decide, who to fire, who to hire, and it's a core power of the presidency, right, is to choose his officers, and he gets to communicate with his officers about how to carry out their roles. That entire conversation is considered absolutely immune. The quote from Roberts would be readily categorized. So easily, that is an absolutely immune thing. That means that not only is anything that he said in that conversation completely not criminally indictable, it cannot be used as evidence in the furtherance of any other crimes. Kind of wild, but the conversations between Trump and Pence with regards to Trump trying to pressure Pence to flip the electoral votes, even the alleged conduct here would be presumptively immune because it is within the roles for the president and the vice president to speak to one another. The only reason why this gets downgraded to at least presumptive immunity is because Congress passes laws with regards to the vice president having oversight over the Congress. So there's some overlap here. Because of that overlap, now the burden is on the government to make the argument that, well, if we do a criminal investigation in regards to this conversation, we have to prove that it wouldn't pose any danger on intrusion on the authority and functions of the executive branch. But because there's some overlap with the federal government's role here, or I'm sorry, with the legislature's role here, the argument is that, well, you know, you can try to make the argument that he shouldn't have immunity here, but he's granted presumptive immunity because it falls squarely within, at the very least, the outer perimeter of what it is to, you know, perform his role as the executive. So this issue was remanded to the lower courts to try to figure out whether or not they can overcome the presumptive immunity that he's been granted for that conversation. Now, 3 and 4, these buckets of actions that he's talking about. The first is communications with state officials with regards to their electors, calling them and saying like, hey, you guys need to toss your electors. You need to change your votes. We think that there was voter fraud. You need to toss whatever, blah, blah, blah. This was completely remanded to the lower court saying you need to figure out which of these actions were official versus which actions were unofficial. And remember, when they're considering that, they can't take into account his motivations for any of these things. Roberts gave absolutely no guidance for figuring out what was official or unofficial. And then on the fourth point, Trump's speech and actions that he made on January 6th in regards to the ongoing insurrection, that was remanded to the lower courts to figure out which actions here were official or unofficial, with no guidance given for figuring out which ones were official and which ones were unofficial. In the concurring opinion, Amy Coney Barrett writes that she agrees with the core of Roberts' argument that there are probably some core powers that we say should maybe be beyond even criminal judicial review, but Justice Barrett has a much more narrow view of what those powers should be, and she takes an issue with the overly broad view that Roberts has written, essentially saying that, I mean, truly, under this official acts bucket, basically anything could be beyond criminal review, depending on how you look at it. And Justice Barrett doesn't like the fact that even if you do say something was an official power and is beyond criminal prosecution, that you can't even use these actions in the furtherance of other crimes. One thing I'll say before I get into a major point of dissent here is Roberts is doing a lot to balance. He's looking at the trouble of what if the executive is constantly worried about criminal prosecution? And he does this thing over and over again where he's like, we need a vigorous and energetic executive, which is a fair thing to consider. I think that's why in the Fitzgerald case, it's why the court said that, well, you know, you probably shouldn't be able to sue the president for everything because every single citizen in the United States could theoretically be filing civil suits against the president. The one thing I don't like is that Roberts never addresses a single time, what about the state or the people's interest of not having a crime-committing president? That is never brought up a single time in all of Roberts' ruling. He only considers the threat of a president having to face criminal prosecution. He never considers the public interest of not having a crime-committing president. There's not a single word addressed to that fear. Which is especially frustrating because there are multiple wild scenarios. I think Jackson brings up the idea of poisoning like an officer that you no longer want to work with you. And Sotomayor brings up the SEAL Team 6 example. And despite Roberts addressing some of the dissent and Roberts addressing even Justice Barrett's, concurring opinion, he never, ever, ever touches on any of the scarier acts. He doesn't address them at all. I don't know why. It's very annoying. Sotomayor is writing the main dissenting opinion, the larger one, with Kagan and Jackson joining in. And she writes that the immunity is legally and historically inconsistent. She believes that the court has gone even further than what Trump's lawyers were asking for, as Trump's lawyers seem to concede that a lot of his conduct was unofficial and that the president might be criminally charged for actions, even if they were official and core powers, as long as he were impeached and convicted first, two things that Roberts rejected in his majority opinion. So a lot of people I've noticed, and we'll get into some writing about this, a lot of people are saying that, oh, well, actually, at least the court didn't go as far as what Trump's lawyers wanted. That is not true. Trump's lawyers were saying that, well, if you want to criminally indict a president for official acts, at the very least, you have to impeach him first. You got to impeach him, and then that has to pass the Senate. Roberts rejects that view. Roberts has not said that if you're impeached for a particular thing, that you can now be held criminally liable for it. He says that impeachment clause makes no statement as to what types of crimes can the president be indicted for. So in my opinion, I would say, and I think some others have said as well, that the court has gone much further in delineating which acts are beyond judicial review and which acts aren't. Sotomayor also points out that there are many federal safeguards in place for criminal prosecution, and that Roberts has failed to engage whatsoever with the idea that the public might have a public interest in having a president who does not feel as though he has any criminal liability while performing his duties. The bias were so strong that the president could never have a fair trial over official conduct. It seems reasonable to believe that he would apply, that this would apply to literally any potential trial involving him, defeating the need for any sort of absolute immunity over any actions at all. Basically, this idea, there's two things going on here. One is there's a heavy indictment of our federal, our federal judicial system. The idea that you could have a corrupt prosecutor that would get an approval from a corrupt judge to file a corrupt indictment that he could put in front of a corrupt grand jury who would corruptly approve it. And then you would have all of your pretrial motions would be thrown out for corrupt reasons. The trial itself would be corruptly performed, and then the jury would make, the new jury for this would make a corrupt conviction, and then the upper courts would corruptly not hear any appeals, all the way up to the Supreme Court that would corruptly, there are so many safeguards in the federal judicial system when it comes to doing indictments and convictions, and Roberts considers none of those. He says, well, none of that would work because all of this would be corrupt because it's the President of the United States. But something that Sotomayor points out that I think is a good point is if the system is that corrupt, why would we expect this decision to help him anyway? Wouldn't you expect to have somebody just randomly indict Trump for just a random murder and just say oh, we're just going to indict him for this. We're all going to go after him anyway. And it's okay, well, if you think it's this corrupt, wouldn't they just convict him on any random thing ever? Who cares at that point, right? So she also remarks that it was not right for Roberts to make a determination of absolute immunity for the conversation between Donald Trump and his attorney general while remanding every single other action back to the district court. If Roberts is saying that the Supreme Court is not a court of first review, the Supreme Court is not in the business of making first reviews or first passes on facts, that's up to the district courts to consider first and then to appeal up to the Supreme Court if necessary, why did Roberts find it necessary to make a determination of absolute immunity over Trump's conversation with the attorney general? Why didn't Roberts remand that back to the court the same way that he did with the conversation between him and Pence, between Trump and Pence? I feel like Roberts should have remanded the Trump and Pence conversation back to the district court and granted it. He would say, it's probably got presumptive immunity. Same thing with the conversation between him and his attorney general, but he didn't do that. I don't know why he made a declaration on one, but he didn't declare anything obviously private or obviously unofficial acts. And then Justice Ketanji Brown, dissenting, writes that while Roberts expresses great concern about the separation of powers that he while Roberts writes a great concern about separation of powers, Roberts obsesses over this idea of separation of powers. Justice Brown points out fairly that the court, in a way, has snatched a huge amount of power for itself because now whatever laws the legislature passes, remember, criminal laws come from Congress. What Congress deems to be crimes are passed in Congress through the form of legislation, and then that goes over to the executive, the president, for enforcement. But the court has said for itself that Justice Jackson, the court has said now that we're actually going to determine whenever the president is breaking the law, the legislature no longer gets to determine that. Because every single time you charge a president with a crime, obviously the president's going to challenge, well, this is official conduct, you can't probe this. And all of those decisions are going to make their way up to the Supreme Court, most likely. And the Supreme Court is essentially going to have the final say over whether or not a president is ever breaking a crime. So they've snatched that criminal enforcement from the legislature, which one might argue is a more severe form of upsetting the balance of power than simply saying that the president should probably be able to be held criminally liable for their actions. The opinion is pretty unhinged. A lot of people are saying that, people are being unhinged with their evaluation of the opinion. I think people can be unhinged sometimes. I don't think people are being unhinged about this. I think that if we weren't worried about Navy SEALs, assassination hit jobs on fellow politicians, I don't know why Roberts wouldn't have just addressed that in his ruling. I don't know why Roberts, because Sotomayor brings this up, exactly, saying that he could order a SEAL team assassination, and Roberts doesn't address that at all. I have no idea why. NoahPinion tweeted or retweeted this. Basically a thread saying that people were being too hysterical, and then we have a 1-hour Ben Shapiro video on it. Oh boy. I guess because this is probably going to come up. I think Tim Pool's Booker reached out to me. I think we're going to do something in a few weeks. I do talk to Michael Knowles soon. I go on his program, I think on the 11th. So I'm pretty sure this question is going to come up quite a bit. So here are questions, I guess, that I would have for people that are supporting this decision or think that it's not a big deal. The first question would be is, can you give a single example of an action a president might want to take that would be chilled by him being criminally liable, even for the core functions of his office? One assumption that's made is that presidents won't be able to act if they feel like they can be held criminally liable. My counterargument would be presidents probably have always felt like they could be held criminally liable. That's why Ford pardoned Nixon. That's why Nixon accepted. Maybe even more importantly, that's why Nixon resigned. I don't think Nixon even dreamed of making this argument that, like, well, actually, there are some things that you can actually never hold me criminally liable for, even if I'm like obviously working, against against my powers or against what the Constitution would want or against the system. Like, there are probably some things you could just never criminally indict me for. I don't think any president has ever operated under that assumption ever. So the idea that like the president might not take some bold action because he's chilled about it being held criminally liable. I'm curious, what actions do you think those are? I really want to know what actions you think the president might need criminal liability to perform to the best of his duties. The second question would be, if we are so worried about presidents infinitely prosecuting prior presidents for criminal matters, why hasn't this not happened yet, right? Apparently, we've seen now that you could always criminally prosecute a prior president. Why hasn't that happened? Again, maybe people are thinking like, oh, well, people have just assumed that's not the case. That's bullshit. Source that anywhere. For a court that is so obsessed with textualism and history, where are your historical arguments that it has ever been the case that a president has been assumed to be above criminal prosecution? Even in the Mueller investigation for Trump, which conservatives love to freak out about all the time, even in that investigation, there were always questions. And I think even Barr, I should have the quotes from Barr. I think even Barr's wondering, can you indict a sitting president? That was always the question. Can you indict a sitting president? Can you indict? Nobody ever suggested, well, actually, some people said you can't indict a sitting president. That's not allowed. Nobody suggested, actually, you could never indict a president or ex-president for having committed a crime. Or at least I don't remember seeing that ever suggested. Like, oh, no, actually, presidents are totally unindictable in a criminal sense. The third point here is, why did Ford find it necessary to pardon Nixon? And why did Nixon accept the pardon if the president was assumed immune from criminal prosecution for acts taken as president? I guess I brought that up for the first point. Like, everything that Nixon done, he could have argued was part of his core powers. The people that he communicated with, these were acts of the president, that probing on any of these might weaken the executive and make them fearful in the future of performing other acts. The fourth question I have is, let's say a president goes on TV and makes a statement that a particular judicial action would deter him from making tough decisions about running the United States. Would this statement in and of itself not shield him from all criminal prosecution with respect to the judicial action he references, or would be to the criminal action that he references, as it could then be cited by the court itself as evidence that the proposed judicial action would intrude on the authority and functions of the executive branch? Like, remember, the threshold that the government has to meet when they're trying to prosecute a former president is saying, oh, this won't affect his ability to do his job at all. But what if a president just goes on TV and says, if I get prosecuted for this, by the way, it will affect our ability to do our job? It's like, oh, okay, well, us, I guess. In that case, we can't prosecute you for it. Like, how do you even make that determination? The fifth question would be, would you be okay, this is for conservatives, would you be okay with the entire cases against Joe Biden and his impropriety with Hunter Biden, or anything having to do with Hillary Clinton, assuming, let's say, she was president, falling under the purview of official acts in accordance with this ruling, thereby making all of their actions absolutely immune from criminal prosecution or judicial review? Remember, all Joe or Hillary has to claim is, well, you guys are going to start going through my servers or going through my emails, going through whatever. Like, I don't even feel like I can operate, without me facing infinite criminal prosecution. I think that Joe Biden could very easily argue that his administration has been hampered by criminal prosecution. Hillary Clinton, if she were president, I mean, she could make the argument that, like, I didn't even get elected president because of this investigation by the FBI. I feel like Hillary Clinton could strongly make the argument that future presidents might be deterred from making certain actions because of potential investigations that could hamper their reelection, right? I think that you can very easily make those arguments. And now, so that means any of those actions would be absolutely immune from all criminal prosecution. None of these are even the crazy SEAL Team 6 things. I think that all of these are very easily arguable. I guess we'll see over the coming days if conservatives want to argue over any of them. The first thing that NoahPinion cited was this Twitter thread. For everything partisan coded, 80% of people will lie through their teeth to serve their tribe's goals. True. So it'll be hard to find an impartial summary of today's presidential immunity SCOTUS opinion, but I don't have a tribe. So here's my just the facts summary. Oh boy. This is always a red flag when people say this. I'm not politically biased. Executive immunity has always been a thing. The underlying rationale is that presidents cannot be encumbered in carrying out their necessary official duties with fear that they will be sued into oblivion for doing so. I don't know what he means when he says executive immunity has always been a thing. if that was the case, then I don't know why the Fitzgerald case would have ever happened, where the Supreme Court granted civil immunity to the president. I don't think it's always been a thing. There's no plain reading of the Constitution that gives you that. I'm pretty sure this is just wrong, but I don't know, maybe you in the comments can link something disagreeing with me. In terms of official acts, a president may, 1, act with constitutional powers reserved solely for the executive branch, 2, with powers shared between or delegated by the legislative, or 3, neither. Presidential immunity is strongest in Category 1 and non-existent in Category 3. So he's kind of like created the 3 buckets of acts in a different way than how Roberts structured it. I don't agree with his structuring here, and I think as we read through, we're going to find out why I don't agree, because I don't think that the way they structured them is the same as how Roberts would structure them. But so for the first thing here, presidents have total immunity in Category 1. Otherwise, it would give Congress and the judiciary power over the executive in an area where it is supposed to have exclusive power. This opinion focuses on Category 2, where Congress delegates or shares powers with the president. So I don't know how nitpicky I want to be. He said he was a lawyer, right? So what has been ruled is that the president has total criminal immunity in Category 1. The reason why the president has criminal immunity is because it would give Congress and the judiciary power over the executive in an area where it is supposed to have exclusive power. So the president, in no reading of the Constitution, in no reading of U.S. history, in no anything, has ever been said to have exclusive power over committing crimes in the course of their job as the executive. That's just not true. Now, in terms of, can the legislature tell the president that he can't have a power that is dictated in the Constitution to him? No, the legislature has no power over that. And can the judiciary rule that he's not allowed to do a thing that he has a core power over? No, the judiciary is not allowed to do that. However, what this ruling has done today is it said the legislature can't make laws that apply to the president at all, even if it's outside of the court powers, because eventually it's going to be the judiciary that decides whether or not the president has immunity from that particular prosecution. And for the first time, the president has been given total criminal immunity when performing acts in Category 1. That's never been the case, okay? The other axis relevant here is whether proceedings are civil or criminal. A president's official acts, which encompass both Categories 1 and 2, are absolutely immune from civil money damages lawsuits. In terms of criminal law, though, we have far less clarity. Well, I would argue we have none. And remember, the official acts are only immune from civil liability because of the Fitzgerald ruling in the Supreme Court. I don't believe that was ever a core thing in the Constitution. I don't think there's a textual reading there. I don't think in Fitzgerald, I didn't read the entire Fitzgerald case, but I don't think that they cite any textual basis for that, because I think if they did, I think Roberts would have cited that instead, or cited that in the ruling. But SCOTUS today laid out the tension. The president needs to be able to act within the scope of office without fear of politically motivated prosecution after leaving office, but the president also cannot be above the law. SCOTUS today said, taking into account these competing considerations, we conclude that the separation of powers principles, he says competing considerations here, but they don't ever really consider whether or not the president can be above the law. They just basically say that, if we redefine the law as such, the president's never above the law, so we don't have to worry about it. I think that's what Thomas says. Thomas writes a little bit about this, but he mainly, in his concurrence, he just dedicates it all to his schizo ramblings about the fact that he doesn't believe that a special prosecutor should ever exist. He doesn't think that Congress is explicitly authorized. I don't know why apparently Thomas writes just random shit in his concurrences for other stuff that he cares about. I don't know why. Apparently that's the thing. SCOTUS today said, taking into account these competing considerations, we conclude that the separation of powers principle necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. What is presumptive immunity? It is a presumption that a president is immune from criminal prosecution for official acts, but that presumption can be rebutted with a showing that prosecution wouldn't violate separation of powers. I don't like his expression here, wouldn't violate separation of powers. This doesn't really make sense, because any judicial review is technically crossing separation of powers. What Roberts has really said is you have to show that it would have no bearing on the executive's ability to carry out its functions as president. That's what you have to show. Not that you're not violating separation of powers, but it would have no bearing on the executive's ability to perform and function those powers. But SCOTUS today said that the president has at least presumptive immunity. The majority said whether immunity here is presumptive or absolute is not a question that needs to be resolved today. In essence, today's decision kicks that can down the road. That's not really true. SCOTUS said in category 1, in the first thing when he was talking about the AG, SCOTUS said that he has absolute immunity for his conversations with the acting attorney general. For category 2, with President and Vice President Trump and Pence talking, he has presumptive immunity. So the district court needs to overcome that presumptive immunity. And then actions 3 and 4, which were Donald Trump talking to state legislatures about the electoral votes and Donald Trump's actions on January 6th, those are remanded to the district courts for a fact analysis to see which acts were official and which acts weren't. So this tweet is just wrong, I think. Up until now, I've only talked about SCOTUS's opining on presidential immunity generally. What does that mean for Trump's case specifically? Well, this may seem strange, but nothing really. I don't know why he would say this, considering they literally ruled part of what he had done absolutely immune from all of the case, which was the AG conversation, but okay. The key question for Trump's case is whether Trump's conduct around January 6th was official conduct. But there's other conduct as well, such as his conversations with the state legislatures, like a lot of conduct before January 6th, but okay. SCOTUS says the lower courts haven't adequately addressed that, and SCOTUS can't address the question on its own initiative. It can only review the lower court findings, although they did address that for the conversation with the AG, which was wild. And so SCOTUS goes on to analyze the alleged conduct to assess whether and what conduct qualifies as official conduct, but with the caveat that it can't do so comprehensively because it doesn't have a comprehensive record. Well, no, they don't analyze any of the conduct for categories 3 and 4. They just tell that because they remand that to the lower courts to make a fact finding, basically. SCOTUS addresses Trump's alleged conduct in 4 buckets. Oh, so here now he's bucketing the 4 different things. Challenging the election results in court, leaning on VP Pence to thwart certification, leaning on state officials and private parties to change state election results, and 4, Trump's speech on and around January 6th. Okay, these 2 are right. I don't know where he gets challenging the election results in court. I don't remember reading that at all anywhere. Unless I didn't miss it. I need to not be as doubtful for YouTube videos. I don't think I don't think Roberts ever spoke about challenging the election results in court. I think that's what he's saying, what the communications with his DOJ are. Oh, that wasn't what the communications were, and that's not what Roberts said the communications were about. He said that the communications were about hiring or firing for the AG and leading investigations for the AG. Bucket 1, SCOTUS says that this conduct has absolute immunity. The executive is given sole authority to investigate and bring cases. True. If you could get around this by saying the cases were shams, every challenge to presidential judgment in bringing cases would claim as much. Okay, but Trump's cases for his election stuff were not cases that were brought by the Department of Justice. So this is not really talking about anything. Bucket 2, SCOTUS says that the vice president presiding over certification is generally not an executive function, but some VP acts presiding over the Senate may be. SCOTUS instructed the lower court to determine whether prosecution on these grounds would intrude on executive function. He's kind of right here, but what SCOTUS actually said is these probably are an executive function, so there's presumptive immunity, and you need to prove why the presumptive immunity wouldn't apply to make sure that so then you need to make sure they don't intrude on executive function. Bucket 3, SCOTUS says the president doesn't have authority over the state's elections. They suggest find me 10,000 votes, and plots to replace slates of electors aren't immune. But they admonish the lower court for not giving them a full record to assess other conduct in this bucket. They don't make an assessment at all about whether or not any of these actions are immune. I don't remember Roberts saying anything about how, well, these are probably private actions. I think Barrett does. Justice Barrett, I think she says these are plainly not official actions. I think she might say this in, I should have written this down. Oh, here we go. Justice Barrett says, sorting private from official conduct sometimes will be difficult, but not always. Take the president's alleged attempts to organize alternative slates of electors. In my view, that conduct is private and therefore not entitled to protection. The Constitution vests power to appoint presidential electors in the states, and while Congress has a limited role in that process, the president has none. In short, the president has no legal authority unless no official capacity to influence how the states appoint their electors. I see no plausible argument for barring prosecution of that alleged conduct. Amy Coney Barrett makes that assessment. Roberts does not. That is not in the majority opinion, the controlling part or whatever, that the president doesn't have authority over a state's elections. I don't know where he's getting that from. And I don't think they admonish the lower court at all. I don't like that phrasing. Bucket 4, SCOTUS says that some presidential speech is squarely official conduct. Other presidential speech isn't, and it's a very fact-specific inquiry. And so the lower court needs to do the fact-finding to determine precisely for each of the things Trump was alleged to have said. In sum, presidents are absolutely immune when investigating and bringing cases. Presidential immunity is shaky at best regarding conversations with VP on certification. To be clear, they didn't say presidential immunity is shaky at best. Roberts said that he has at least presumptive immunity there, so I don't know where he gets this. Presidents aren't immune for pressuring state election officials. He doesn't say that either, and the lower courts need to determine the rest. Next, SCOTUS makes clear that if the court determines he has immunity for a given act, he cannot face criminal prosecution for that act. They also add that those acts cannot be considered by the jury when prosecuting the president for other non-official acts or for anything. Finally, SCOTUS considers and rejects Trump's far broader argument for immunity. Trump's team argued that he can't be prosecuted for anything unless he is first impeached and removed for it. SCOTUS says there's no textual support for this argument. While that's true, Trump's legal team did concede that he could be criminally indicted for anything if he was impeached for it. So in some ways, it's more narrow. In other ways, it's far broader. Okay, depends. The dissent and commentators all over social media are decrying this decision and saying things like, this decision would allow the president to assassinate his political opponents using SEAL Team 6. There is absolutely no support in the majority opinion for this. Then the question is, why didn't Roberts address that? SCOTUS could and likely will rule further on immunity in this case, but it has also signaled several instances of Trump's conduct that do not have immunity. And no, they didn't signal a single act that wouldn't have immunity clearly. Only in the concurring opinion did Justice Barrett suggest that some act would clearly be non-official and or may not have immunity, depending on what the lower court ultimately finds when it does more fact-finding. For the dissent and for these social media takes, the opinion has this note. They strike a tone of chilling doom that is wholly disproportionate to what the court actually does today. Wow, congratulations. Correct. The majority opinion does flex over themselves to self-suck themselves about their opinion. I don't know why this citation means anything, but okay. Okay, and then we have Ben Shapiro's take.
So yesterday, pretty much all hell broke loose. It didn't break loose because of a Supreme Court decision. It broke loose because the left has decided, along with the media and the Democrats, but I repeat myself, to lie about the Supreme Court decision in order to revive the flagging hopes and dead body of Joe Biden. Let me begin at the beginning. Yesterday, the Supreme Court released a decision about presidential immunity. Now, this decision, of course, is rooted in Donald Trump filing a lawsuit to stop the various Jack Smith lawsuits against him. His claim was that as president of the United States, no matter what he did while he was president of the United States, he has full immunity from criminal prosecution. That, of course, is not true. That is a step too far. The idea that the president of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the president of the United States decided that in his home, in the White House, he was just going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes.
That's fine that Ben Shapiro says that. We don't know the answer to that, though. We have no guidance on that whatsoever. So this is fabricated from his mind and pulled from nothing.
Step too far. The idea that the president of the United States is never, for any activity, able to be criminally prosecuted is really silly. If the president of the United States decided that in his home, in the White House, he was just going to murder a maid, for example, could he be criminally prosecuted? The answer, of course, is yes. However, there is the idea that the president is, in fact, criminally immune from certain activities that a normal person would not be. So, for example, if I authorized somebody to go kill somebody abroad, I'd be criminally liable for that. If I'm president of the United States and as commander-in-chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that.
Okay. Sorry. Wow. Hold on. This is so wrong. I'm sorry. I'm irritated for a few reasons. The president has already understood to have had criminal immunity from these types of criminal charges because the president has been explicitly tasked with the legislature for performing some of these acts. It's either in the official capacity of the president to perform some of these acts, or the legislature has empowered him to via legislation. We've never, ever, ever needed a Supreme Court to tell us that the president has criminal immunity from that. The idea that we needed this decision today to spell that out is entirely inconsistent with the history of the United States. It has never been suggested. When Barack Obama drone-striked an American citizen and he consulted, his legal counsel for what was okay with, it has never, ever been suggested that the president requires criminal immunity to do his job. That's never been suggested. So the fact that we needed a Supreme Court to tell us this is ridiculous.
If I'm president of the United States and as commander-in-chief, I authorize SEAL Team 6 to take out Osama bin Laden, I'm not going to be criminally liable for that. So there's plenty of stuff that the president of the United States has to be able to do in order to ensure the functioning of the executive authority of the United States. The president does have outsized powers under our Constitution. Those powers are not endless. Immunity is not eternal and endless. That is not the way that immunity works.
We have no guidance on what core powers even are. We've gotten a few from the Constitution, but in terms of like what are the core powers that are exclusive, we don't actually know. There was nothing given. There wasn't a list given by Roberts, and there wasn't even a good way to determine what those are other than this conclusive and preclusive, this idea of what a conclusive and preclusive power is. And
that's basically what the Supreme Court found. So in order to understand why the left is lying about this decision and why Joe Biden is lying about this decision and the political games that are now being played, you have to understand the decision itself from the Supreme Court. So I'm going to go through that decision in a little bit of detail because the sort of final effect of this as far as President Trump is that there are a couple of charges that Jack Smith has been pursuing that are basically DOA, and then there are several charges that are not DOA, and that will likely be upheld when this thing is reverted back to the D.C. Circuit Court of Appeals, because that's effectively what the Supreme Court did. They took...
Maybe, but the problem is that if you can eliminate enough acts as core acts, maybe you have other things that you'd want to indict Donald Trump for. However, if you've eliminated enough acts that aren't now able to be considered as evidence for whatever other crimes you're trying to charge, you have no case, right? Let's say that I go to the head of my FBI and I say, hey, listen, I want to steal a horse, okay? I really want to steal a horse. I think that you should hire an agent to go and find out who has the best horses, okay? Otherwise, if you don't, I'm going to fire you, all right? Okay, then the FBI reports back and we found this, and then he goes to the DOJ and he's like, listen up, okay? Listen up, Attorney General. We're gonna sue this guy who has, who has a farm. I want you to sue this guy, and we're going to, if you don't do this, I'm firing you, okay? You need to do this, okay? We're gonna bring a case against the guy. Well, not sue him, it'd be a criminal case against the DOJ, right? And he's like, okay, Jesus, okay? So they bring a case against him. Let's say the case isn't going too well. Then the president goes to the head of the CIA and like, listen, I just need you to, can you take this guy out? But also, can you like deliver the horse to my, I want you to deliver the horse to my backyard so that I can ride this horse around. I really want this horse. And the head of the CIA is like, okay, well, and he's like, I'll fire you if you don't do it. Okay, fuck it. Okay. In all three of these actions, all right, the president has implicated core powers that are conclusive and preclusive to his office. All right. Let's say that everything happens, the FBI finds the person, the DOJ tries to prosecute him, eventually the CIA kills him, and then the horse has been delivered to the president's backyard and he's riding around on his horse. Let's say that a criminal investigation happens and they find out, okay, well, clearly the conspiracy is all here. We've seen all of the actions of Donald Trump and all the things he said for these heads. He clearly conspired to set up this whole plan to get this horse in an illegitimate manner. However, you can't begin to even probe on that because all you could talk about is the fact that a horse showed up in Donald Trump's backyard. That's it. You can't bring up any of the conversations that he had as evidence in any of those three circumstances because it is the conclusive and preclusive power of the president of the United States to have conversations about with his officers about how those executive departments carry out their jobs and talking about hiring and firing people. That's all exclusively within the purview of the president, and it's unquestionable insofar as his immunity goes. Absolute immunity here. So in this case, the president would get away with that, and there'd be nothing you could do about it. All you could bring up is the fact that he has a horse. This is brought up. Roberts tries to address this by saying, well, actually, so in oral arguments, this was brought up as the one-legged stool thing, right? What if a more simple example, it doesn't involve horses in three different executive departments, what if the president takes a bribe for a pardon? Well, you can talk about the bribe, but you can't talk about the pardon. And I think it's Sotomayor that brings up, how do you prosecute somebody for doing a quid pro quo if you can't talk about the quid or you can't talk about the quo? And Roberts' way of getting around this is Roberts like, well, you could consult the public record that shows through some through some unofficial action, the president saying, well, I'll accept a bribe, if he says it publicly in a non-official act, but it's obviously like a ridiculous, it's a ridiculous way to try to get around that. I'm sorry. Justice Barrett actually brings this up. This is Roberts' attempt to head that off. Justice Barrett disagrees, arguing that in a bribery prosecution, for instance, excluding any mention of the official act associated with the bribe would hamstring the prosecution. But, of course, the prosecutor may point to the public record to show the fact that the president performed the official act, and the prosecutor may admit evidence of what the president allegedly demanded, received, accepted, or agreed to receive or accept in return for being influenced in the performance of the act. What the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself. Allowing that sort of evidence would invite the jury to inspect the president's motivations for his official action and to second-guess their propriety. As we have explained, such inspection would be highly intrusive and would seriously cripple the president's exercise of his official duties, and such second-guessing would threaten the independence or effectiveness of the executive. So I have no idea how the Roberts thinks that this prosecution could ever be successful, because remember, when you're talking about a criminal prosecution, your standard for conviction is beyond a reasonable doubt. Okay, it's not just a preponderance of evidence. It's not like a civil case. You have 51%. It's not a preponderance. It's you have to prove something beyond a reasonable doubt. And now we're not allowed to bring up any of this stuff if we're trying to do a criminal prosecution.
A couple of charges, they said the president has immunity for this sort of activity. And then they said about many of the other charges, we're not going to rule whether the president has immunity on this sort of activity. We instead are going to send it back to the D.C. Circuit Court of Appeals to determine whether the president has immunity. Judge Chutkan is the judge in that particular case. Presumably, she's going to rule that President Trump does not have immunity on those particular charges. So, in essence, this is a very in-between decision. Now, you could have known that by the fact that the writer of the decision was Chief Justice Roberts. Chief Justice Roberts is, in fact, a fairly moderate justice. He is not Justice Samuel Alito. He is not Justice Thomas. He is not one of the more right-wing members of the federal judiciary. Remember, it was Justice Roberts who saved Obamacare way back when. Justice Roberts has a view of the court that it should be minimalist in how it approaches decisions. It should draw decisions as narrowly as possible. So, in this particular case, he said, okay, we're going to try to create some sort of system, some sort of framework for thinking about when the president is immune from criminal liability. And
the idea that this was a narrow decision when Roberts has fabricated out of thin air these concepts of absolute and presumptive criminal immunity that apply to every action that he has created out of thin air, this new test for a state overcoming this presumptive immunity, that, like, the idea that this is a narrow ruling is hilarious. This ruling is quite broad and quite extensive. And Roberts almost says this himself when he's like, we're not trying to rule just on Trump's case. We need to figure out like a rule that works for like every future situation like this going forward. I disagree here that, oh, well, it was just a narrow ruling.
When he is not. But we're going to restrict our judgment to very specific aspects of the charges being brought against Trump. We're going to say only a couple of these he has absolute immunity on. And the rest of this stuff we're going to push back to the courts. That does not sound like President Trump or any other president has endless immunity. The kind of immunity that the dissent in this case suggests. The dissent is written by Justice Sonia Sotomayor, who writes all of her opinions in crayon, because she is not an intelligent person and apparently does not know how to read the law.
So to be clear, Sotomayor's reading of the law and the underlying Federalist Papers is vastly superior to Roberts. For instance, when Roberts cites over and over and over again to Federalist Paper 70 or 77 about this energetic executive over and over and over again, all he's citing to are people talking about why the executive doesn't need to be opposed by, multiple members of the executive, that you shouldn't have co-equal executives that are executing the law. None of these citations that Roberts makes ever are alluding to anybody talking about the need for infinite criminal immunity from criminal charges for the president. So, and Sotomayor's citations, in my opinion, are vastly superior if you read any of the underlying material, which I know people don't like to do. But this idea that Roberts, who cites over and over again to Fitzgerald a case about civil immunity and doesn't make any good or unique or prescient arguments on his own, or the fact that he's citing to a civil immunity case where it seems that every single justice there is also saying like, well, obviously if this was used in the case of criminal immunity, it would be ridiculous, but we're only talking about civil immunity here. The idea that Roberts is writing a more intelligible opinion here is ludicrous.
As it turns out on Twitter, pretty much nobody knows how to read the law, or they're just lying about it. By my count, about 80% of the legal analysts on Twitter fail basic reading comprehension. Another 17 or so % succeed in understanding the decision, but then lie about it. So what does the decision say? So the Supreme Court starts its decision by defining the crimes for which Trump is being charged. And they essentially break them down into 5 categories. 1, he tried to get state electors to change their votes. 2, he organized fraudulent state electors. 3, he tried to use the DOJ to conduct what Jack Smith called sham investigations, meaning investigations into electoral fraud that were really poorly based and resulted in nothing. 4, he tried to persuade Mike Pence to alter the results. And 5, he tried to convince members of Congress to delay certification. Now, all those things...
I'm so curious if it's like I don't know how you would get 5 from here, especially now that I've read the opinion, I've taken notes. I'm so curious how anybody would bucket these things in this way. If this is like a ChatGPT analysis, or like if there are like underlings that do the analysis, like why would you separate it out this way? They're not in the order they were presented in the opinion. So they're out of order, which maybe you organize your notes that way. That's fine. But then also they're... You've given 5 when there were only 4. I'm curious what the process is. I wish I could see, like, how do you do your research? How do you write these things down? How do you group these things the way that you do? I'm so curious how.
To alter the results. And 5, he tried to convince members of Congress to delay certification. Now, all those things, in my opinion, are morally wrong. That does not mean that they are legally criminal. And that's particularly true if you're president of the United States. Because as the court points out, you're the head of the DOJ. There are only 3 branches of government, not 4. The DOJ is not an independent branch of government. The Department of Justice works for the president of the United States. If the president orders the DOJ to go ahead and investigate a thing, it is the job of the DOJ to go ahead and investigate the thing. So that falls within his purview of authority. Okay, so we'll get to how the actual ruling affects these various cases against Donald Trump. Well, this Supreme Court decision is really important. The Supreme Court actually made another decision last night about social media companies. They didn't come down hard on these social media companies. Here's the thing. Social media companies, they get to decide what content is suitable for the snowflakes among us and censor whatever they don't like. The Supreme Court didn't stop them from doing that. But shouldn't you be the one to decide what you want to read or watch, not them? Here's one thing you can control, their access to your data. For that, I use ExpressVPN. The problem with big tech companies is not only do they censor what you read, they track what you do online. They track what you're searching for, the videos you watch, everything you click. They use this data to serve you ads. They can match your activity to your offline identity using your device's unique IP address. When I use ExpressVPN, these tech companies can't see my IP address at all. My identity is masked and anonymized by a secure VPN server. Plus, ExpressVPN encrypts 100% of your data to protect you from hackers and internet bad guys. Does that sound complicated? Well, it's not, I promise. ExpressVPN software takes just 1 minute to set up on your computer or phone. You tap one button, and now you're magically protected. Why give these tech companies a free license to know everything about you and then turn around and sell off your information? Take back your own privacy at expressvpn.com/Ben. By visiting my special link, you get an extra 3 months of ExpressVPN service for free. Who doesn't like to save money, right? Again, that's expressvpn.com/Ben, expressvpn.com/Ben to protect your data today. So here's what the Supreme Court writes. The parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. They also agree that some of the conduct described in the indictment includes actions taken by Trump in his unofficial capacity. We conclude that under our constitutional structure of...
I don't know where this agreement comes from. Did I miss this? Has nobody pointed this out to me? Roberts does not explicitly say anything is an unofficial act. He suggests that there are 2 categories of actions that require a fact analysis, and he remands that to the lower court saying they haven't done any. But the concerns we noted at the outset, the expedition of the case, the lack of factual analysis by the lower courts, and the absence of pertinent briefing by the parties thus become more prominent. We accordingly remand to the lower court to determine in the first instance, with the benefit of briefing we lack, whether Trump's conduct in this area qualifies as official or unofficial. I don't think Roberts makes a single suggestion that any act might be unofficial. I don't think he does. I think that Justice Barrett does, but I don't think, I'm sorry, did I say Jackson? I don't think Roberts does, but I don't know.
Separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the requires that a former in his unofficial capacity. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official actions, he is also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient.
Except they do for one act, which was the conversation with the Attorney General. He does decide that, but...
And so let's start from the beginning. Why does the president need immunity at all? Why does he need immunity at all? The answer is, again, the executive has to be able to function in the constitutional order. So as the Supreme Court writes under Justice Roberts, a president inclined to take one course of action based on the public interest may instead opt for another, apprehensive that criminal penalties may befall him upon his departure from office. And if a former president's official acts are routinely subjected to scrutiny in criminal prosecutions, the independence of the executive branch might be significantly undermined. The framers' design of the presidency did not envision such counterproductive or burdens on the vigor and energy of the executive. The court also...
No source, by the way. No source for that at all. Strange that the dipshits that wrote our Constitution saw fit to put a criminal exemption for speakers in the House and the Senate when they were speaking, that they would be exempt from all criminal prosecution, but they just didn't write anything like that for the president. Oof, that was pretty dumb of them to not write that when they obviously the framers intended for our president to be immune from any law passed by the legislature, immune from all criminal prosecution, obviously.
And of the presidency did not envision such counterproductive or burdens on the vigor and energy of the executive. The court also said there are, in fact, countervailing interests at stake when it comes to, say, criminal liability. Quote, we must, however, recognize the countervailing interests at stake. Federal criminal laws seek to address a wrong to the public as a whole, not just a wrong to the individual. There is therefore a compelling public interest in fair and effective law enforcement. The president charged with enforcing federal criminal laws is not above them. So in other words, the president is not above the law, but there are core constitutional functions where the president is immune.
Wait, what was...
Law enforcement. The president charged with enforcing federal
criminal law seeks to address a wrong to the public as a whole. Okay, I'm just going to read this. I don't know if he's going to read past this. There is therefore a compelling public interest in fair and effective law enforcement. The president charged with enforcing federal criminal laws is not above them. Chief Justice Marshall's decision in Burr and our decision in Nixon recognized the distinct interests present in criminal prosecutions. Although Burr acknowledged that the president's official papers may be privileged and publicly unavailable, it does not grant him an absolute exemption from responding to subpoenas. So he didn't get an exemption even in responding to subpoenas. Nixon likewise recognized a strong protection for the president's confidential communications, a presumptive privilege, but it did not entirely exempt him from providing evidence in criminal proceedings. Now, okay. This is what I mean. This is what I mean when I said Roberts doesn't ever argue with this. So, okay. So he does reference at least that these other 2 cases brought up the idea that, okay, well, obviously we're not going to give him unlimited criminal shielding, right? That'd be crazy, or any criminal shielding, right? Okay, so how does Roberts deal with these opinions in these prior cases? Taking into account these competing considerations, we conclude that the separation of powers principle explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Such immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. He doesn't even So there's no public interest at all? Like, why do we feel like the president needs to feel safe from crimes to carry out his function of the executive branch? Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers, when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. Really? Why would we assume that just because, there might be a standard for subpoenaing somebody, that if there's some protection for like national security stuff being subpoenaed, then there needs to be full criminal immunity for a prosecution? It's so wild. I can't believe there's just this one thing here, and then like that's it. It's like, okay, whatever.
Criminal laws is not above them. So in other words, the president is not above the law, but there are core constitutional functions where the president is immune. So for example, you could not bring a criminal prosecution against Barack Obama for droning Anwar al-Awlaki despite the fact that he's an American citizen overseas because he was a terrorist. Okay, so for all the Democrats who are freaky...
Wait, really? You don't think you could do that? Well, I mean, I'm sorry. You don't think you could have done that before this decision? Do you think this decision changes that? Like, if you couldn't bring that criminal suit against Obama, it's because Obama has been tasked with carrying out the national defense functions of the United States of America. Like, you can say that maybe it was wrong, or it was a mistake, or that department shouldn't have that power, or that the legislation needs to make more restrictions or something like that. Sure, but that he personally committed a criminal act? That's just never been a serious consideration.
Out today, and as we'll see, claiming that Donald Trump now has the capacity to activate SEAL Team 6 to kill his political opponents. By the way, if Donald Trump had that authority, the current president is Joe Biden, so he could do that to Trump today. I notice that Joe Biden isn't doing that because he doesn't believe this, because no one believes the claims the left are making.
Or because the Democrats act fundamentally differently.
About this particular case. But the actual person being protected here, on this score, would actually be Barack Obama for droning people like Anwar al-Awlaki. So,
except you would never be able to convict Obama acting as the commander-in-chief, executing authorities given to the commander-in-chief, tasked with like national defense stuff on counsel from his legal department. You would never argue that he had the criminal intent, the criminal state of mind, where you could convict him for the crime of murder. That's unbelievable.
Here is how this actual decision breaks down. There's an excellent flowchart that was put out by a group called Just Security, run by Ryan Goodman. And here is sort of how this decision breaks down. So there are effectively two types of conduct that the president can participate in. One is official conduct and one is unofficial conduct. So unofficial conduct would be the president stripping an intern, right? That's unofficial conduct. Or lying about stripping an intern, right? That has nothing to do with the presidency of the United States. That's just the president in his private capacity, basically doing private things that are criminal. So can that person be prosecuted? The answer for unofficial conduct is yes. Okay, so how does that break down in terms of the Trump cases? We'll get to in a moment. Then there's the second type of activity, official conduct. Official conduct under the Supreme Court decision breaks down into two categories. One is core, absolute immunity categories. Core official acts. So what would that be? That'd be like pardon power, or firing people who work in the executive branch, or controlling recognition on the determination of foreign countries. Right? That's stuff that is like core presidential power. So if the president decided tomorrow to recognize an independent state of Kurdistan, he couldn't be criminally prosecuted for that, for example. He would have absolute immunity.
Or if the president accepted a bribe to recognize the independent state of Kurdistan, he wouldn't be able to be prosecuted for that.
And then there's a second type of official conduct, and that would be official actions with presumptive immunity. So this would be kind of like the confusing gray area. So let's say that the president, for example, is pressuring Vice President Mike Pence to change the elector scheme. So the president very often has conversations with the vice president about a wide variety of topics. That in and of itself is in fact official conduct, but he's pushing the vice president to do a thing that is plainly not inside the constitutional structure. And not only that, if you prosecute the president for that, is that going to impede the functioning of the president on a go-forward basis, right? That is the question. When it comes to presumptive immunity, the idea is that there is a burden that the prosecution has to overcome. That we presume immunity for the president, but that can be overcome. Absolute immunity means done, right? There is no case you cannot prosecute the president. Presumptive immunity means that we can presume the president has a certain level of immunity, but that can be overcome by a showing that prosecuting the president on a particular charge does not in fact threaten the functioning of the constitutional structure. So here's what the Supreme Court writes. When it comes to absolute immunity, quote, the president is absolutely immune from criminal prosecution for conduct within his exclusive sphere of constitutional authority. Again, that would be like the president telling the DOJ to investigate a thing, right? That's a core constitutional function. You may not like what he does, that's a core constitutional function. That's not prosecutable. That's how it shakes down in terms of the Trump case. Then you have those remaining official actions with presumptive immunity. And here's what the Supreme Court writes about that. Of course, not all of the president's official acts fall within his conclusive and preclusive authority. As Justice Robert Jackson recognized in a case called Youngstown, the president sometimes acts pursuant to an express or implied authorization of Congress or in a zone of twilight, where he and Congress may have concurrent authority. Taking into account these competing considerations, we conclude the separation of powers principles explicated in our precedent necessitate at least presumptive immunity from criminal prosecution for a president to act within the outer perimeter of his official responsibility. Such an immunity is required to safeguard the independent and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. Indeed, if presumptive protection for the president is necessary to enable the, quote, effective discharge of his powers.
I wish some examples were given by Roberts. Give me one example of an action the president might need to do where people might confuse him with, like, committing a crime. Like, I have to be able to commit crimes, or people might think I'm committing, like, give me an example of this.
A prosecutor merely seeks evidence of his official papers and communications. It's certainly necessary when a prosecutor seeks to charge, try, and imprison the president himself for his official actions. Okay, so, again, this category, which is presumptive immunity, can in fact be overcome by a showing that the president's functioning will not be impeded by the prosecution of the president. So in this category for Trump would probably fall his pressure on former Vice President Mike Pence. So I would assume that the appeals court in D.C., Chutkin, is going to find that that charge is totally fine. You can charge Trump with pressuring Pence to overrule the electors, because that's not within his sort of official capacity to the extent necessary to provide him absolute immunity. So they remand this to the lower courts for explication, saying, as we explained below, the current stage of the proceedings in this case does not require us to decide whether this immunity is presumptive or absolute. Certain allegations, such as those involving Trump's discussion with the acting attorney general, are readily categorized in light of the nature of the president's official relationship to the office held by that individual. Other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Although we identify several considerations pertinent to classifying those allegations and determining whether they're subject to immunity, that analysis is ultimately best left to the lower courts to perform in the first instances. So again, what does this mean? It means that certain of these charges are going to get thrown out, like the DOJ charge, but a bunch of other charges not. A bunch of other charges are likely to be preserved against Donald Trump criminally. Now, in terms of timeline,
Likely? Really?
because this is now going to get remanded back to the lower court, that means that the timeline here is stretched. That means Trump is not going to get charged on any of these criminal activities. He's not going to go to court on any of these criminal activities, alleged criminal activities, until after the election, which is why the left is so all-fired mad. So the timeline on Trump's trials has now been moved out, which is good for Trump's election. But listen, the amount of uncertainty in the world right now is insane. Saudi Arabia, for example, recently ended its 50-year petrodollar deal with the United States. It has the potential to weaken the U.S. dollar. I mean, so does our gigantic national debt. Well, if there's less demand for the U.S. dollar, what exactly happens to its value?
Gold.
For reasons like this, I feel it's important to diversify some of your savings into gold. You can do that with the help of my friends over at Plan 8, limited star friends over at Birch Gold. Her dissent is just lies. I mean, as we will see, the dissent written by to 989898 today to hook up with my friends over at Birch Gold.
Thanks.
And now, as we'll see, the dissent written by Justice Sonia Sotomayor, she of the double-digit IQ, her dissent is just lies. I mean, it's just absolutely untrue lies, as we'll get to in a second. And the Supreme Court majority opinion rejects her read of the case. Okay, the Supreme Court majority says, quote, as for the dissents, they strike a tone of chilling doom that is wholly disproportionate to what the court actually does today. Conclude that immunity extends to official discussions between the president and his attorney general, and then remand to the lower courts to determine in the first instance whether and to what extent Trump's remaining alleged conduct is entitled to immunity. Unable to muster any meaningful textual or historical support, the principal dissent suggests there is an established understanding that former presidents are answerable to the criminal law for their official acts. Conspicuously absent is mention of the fact that since the founding, no president has ever faced criminal charges, let alone for his conduct in office. Accordingly, no court has ever been faced with the question of a president's immunity from prosecution. All our nation's practice establishes on this subject is silent. Okay, now, why exactly the Supreme Court has to write all of that is pretty obvious. Okay, and the answer is because Sonia Sotomayor, in her true political fashion, has decided to just lie about what the majority opinion does.
Where is the textual or historical evidence then? Historical? Is Nixon now, that's history? That's ancient, that's our historical, that's our foundational, that's our framers' intention in writing the Constitution and figuring out our separation of powers? Really?
So she writes an absurd dissent, and this dissent becomes the basis for every Democratic talking point. Here is where things become perverse. So I've spelled out to you how this decision works. The decision is actually quite mild. It suggests that core official authorities of the President of the United States are immune from criminal indictment. Non-core
and can't even be used in the furtherance of other crimes.
Official activities are subjected to presumptive immunity that can be overcome by showing that you're not harming the constitutional order by criminally indicting the president.
Not harming the constitutional order, show that you're not impeding on or hurting at all the executive's ability to carry out their functions. So you have to show that it wouldn't even impede at all in hurting the executive's ability to carry out their functions.
And then there are unofficial acts in which the president can be indicted willy-nilly.
Of which, who the knows what an unofficial act would ever be? It seems like almost everything could be theoretically an official act.
That seems like a fairly rote and along the basic lines of logic decision. That's not how Sonia Sotomayor takes it. She decides to go absolutely hog-wild nuts over this thing. Why? Well, because she's a militant left-winger. And so her goal is to suggest that the Supreme Court has now given the president, presumably Donald Trump, even though he's not the president right now, absolute criminal immunity for literally everything, which is clearly not what the Supreme Court is doing. So here's what she writes in her unhinged dissent, and it is totally unhinged. I mean, this lady needs some Thorazine. This is a wild dissent.
Man, I can't wait to hear his factual rejections of her arguments and the way that he deals with her arguments rather than over and over and over and over again ad hominem her. Oh boy.
She says, today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle, foundational to our Constitution and system of government, that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all the immunity he asked for and more. Now, that's not even true. Trump asked for immunity for everything. If that were true...
That's not true. Trump did not ask for immunity for everything. They said that he couldn't be prosecuted for some things without being impeached and convicted by the Senate first. That's what the ask was. The ask was, hold on, if you want to charge my client with a crime, you need to impeach him first. He didn't ask for permanent immunity from everything. Even Trump's counsel didn't ask for that.
They would not have remanded multiple of these charges back to Chutkin, who is presumably going to uphold the charges. President Trump, all the immunity he asked for and more. Now, that's not even true. Trump asked for immunity for everything. If that were true, they would not have remanded multiple of these charges back to Chutkin, who is presumably going to uphold the charges.
What do you mean uphold? They didn't remand the charges back to him to uphold the charges. They remanded them back to him for him to do a fact analysis, because there's been new categories of immunity created by the Supreme Court that have never been created before. And now we need to do a factual analysis to try to figure out how these even fit into our new paradigm of what a president can or cannot be held criminally liable for.
So that's just a lie, right off the bat. Okay, she continues. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. Really? How many criminal prosecutions of the president have we had since the founding? 0.
Yeah, but why is that? Maybe that's because presidents are, one, exceptional characters. We haven't had that many presidents, okay? To be the president of the United States is pretty exceptional. And two, maybe because presidents generally don't think they can get away with committing crimes. So they don't commit crimes while they're in office.
Founding. Really? How many criminal prosecutions of the president have we had since the founding? 0 is the answer. This new official acts immunity now lies like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country and possibly the world, says Sonia Sotomayor. When he uses his official powers in any way, under the majority's reasoning, he will now be insulated from criminal prosecution. That's not even true. If he uses his powers in improper ways that are outside of his core official position, then a presumptive immunity can be overcome, as I've now...
Wrong. If it is a conclusive and preclusive power that is a core, it can never be questioned. Doesn't matter how he uses it. That's what absolute immunity is. As soon as you start saying, well, it depends, that's not absolute anymore. So she's talking about the definition for the absolutely immune acts, and those are not questionable regardless of how you use them.
From criminal prosecution. That's not even true. If he uses his powers in improper ways that are outside of his core official position, then a presumptive immunity can be overcome, as I've now explained about 4 times on the show. But since she apparently...
Presumptive immunity is only if it falls outside of those conclusive and preclusive powers. That's the only time this presumptive immunity applies. Otherwise, it's absolute immunity.
Apparently cannot read. Here's what she comes up with, Sonia Sotomayor. And this is nuts. Okay, this is just nutso, bizarro world, straight from the asylum crap. Here she goes. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup.
He skipped over all of her opinion just to go to the he read her intro, which is going to have the most charged language, by the way, because that's what you do. You're the dissent, and so in the beginning, of course, you're going to write, this is a sham. That's what you do. And then you make all of your arguments, of which she did, and now you've got like your final paragraph where she talks about, well, these are the bad things that could happen. He basically read her opening and her ending. He didn't deal with any of the arguments in the middle, really?
To hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he might one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. That is, like, every element of that is false. Every element of that is false. Orders Navy SEAL Team 6 to assassinate a political rival? Okay, so the president has a conference. Let's take this to its logical conclusion.
Okay, let's do
Using
this.
the model
Yes.
that we have set up
Yes.
under the Supreme Court majority.
Yes.
The president does speak to the military. The military does control SEAL Team 6. So that in and of itself is inside the official act. However,
Correct.
the president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed.
He doesn't understand the ruling. Did Harvard stop teaching lawyers how to read law? He's making this mistake, and it was the same one that Connor was making. He's making the mistake that to overcome the presumptive immunity, you have to show that the action was really bad. Let's say that the president orders a thing to execute his opponent or assassinate his opponent, well, we can overcome the presumptive immunity because it's really bad. That's not the test. The test for overcoming presumptive immunity has nothing to do with how bad the act is. The test has to do with, if you are allowed to probe on this, will it impede the executive in any way from functioning in the future? That's the test. Nowhere does Roberts say, well, if he does a really bad thing, then fine, you can, then we can hold him criminally liable. That is not the test. Any actions taken under the official acts are granted presumptive immunity in order to protect the president's ability to execute the duties of his office fearlessly and fairly. This means that the burden is on, quote, the government to argue that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and function of the executive branch, end quote. Nowhere does Roberts ever suggest that if the action is really bad, then you can criminally prosecute. That is not the case.
No, the president ordering them to do something blatantly illegal, like murder his political opponent, prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed.
Why? Why? How? In what way? How does that overcome the presumptive immunity? What do you think it means to overcome the presumptive immunity? Sorry.
In fact, if the president were not, in fact, criminally indicted for ordering his political rival to be killed, then that would threaten the constitutional order.
Whoa! Yes! Yes! Holy shit! He unintentionally stumbled upon the incredibly important countervailing interest that Roberts never addresses. That is true. Having a president that could infinitely commit crimes would threaten the constitutional order. Correct! Yes!
Criminally indicted for ordering his political...
I think actually, yeah, hold on. I think somebody should bring this up. I think Roberts might even explicitly say, Roberts might have even said explicitly that the legality of an action can't even be, it's not even relevant. I'm trying to remember if he said that explicitly or not. He did? Yeah, fuck, what was he? Oh, here we are. Nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. For instance, when Fitzgerald contended that his dismissal violated various congressional statutes and thus rendered his discharge outside the perimeter of Nixon's duties, we rejected that contention. Otherwise, presidents would be subject to trial on every allegation that an action was unlawful, depriving immunity of its intended effect. So no, just because you're saying that an action might allegedly violate a generally applicable law, that doesn't mean that you can all of a sudden make that action unofficial. The test has nothing to do with the legality of the action. The test has to do with imposing an undue burden on the executive and hurting the executive's ability to do its job. That's what the test is. You will not hear Ben Shapiro reference at any point Roberts saying anything along the lines of, oh, well, if the action is mega illegal or horribly illegal, then it's not an official action. That's not part of the test at all.
Political opponent. Prosecution of that crime would certainly overcome any presumptive immunity the president has in ordering his political rival to be killed. In fact, if the president were not, in fact, criminally indicted for ordering his political rival to be killed, then that would threaten the constitutional order.
Yeah.
Obviously and clearly. Again, Joe Biden doesn't even believe this. Nobody believes this. If they believed this, Joe Biden would have put out the hit on Donald Trump yesterday. He already authorized his DOJ to try and jail his political opponent. Notice the reversal that's taking place. Joe Biden's DOJ is trying to jail his political opponent in an election he is losing. And now his suggestion is that if his opponent wins office, then somehow Joe Biden's going to be driving down the street and Donald Trump's going to hit him with a drone. It's so ridiculous. I'm sorry, this is ridiculous garbage.
I don't know how any of these things related at all. I don't know what any part of this, I don't know how those two things remotely relate to anything.
Opponent in an election he is losing. Notice the reversal that's taking place. Joe Biden's DOJ is trying to jail his political opponent in an election he is losing. And now his suggestion is that if his opponent wins office, then somehow Joe Biden's going to be driving down the street and Donald Trump's going to hit him with a drone. It's so ridiculous. I'm sorry.
I don't understand the comparison at all. Yeah, the DOJ is free to investigate things as they wish and pursue charges and everything through the federal court systems as they wish. Yeah, they are doing that. I don't know what this has to do with anything whatsoever. How does that relate to anything we're talking about? Or how does it relate to any of the expansion of executive criminal immunity now? That's how I say expansion. I should say the fabrication of the creation of, yeah.
Sorry, this is ridiculous garbage. Sonia Sotomayor concludes her bizarre and nonsensical dissent, quote, never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. Our democracy. Okay, I noticed something about the our democracy crowd. The our democracy crowd is perfectly willing to destroy the Supreme Court wholesale, as we'll talk about in a moment.
Oh, so we're done? We're not going to talk about any of the factual parts, any of the actual legal contentions or citations she makes in her thing. We're just going to go over the first and last paragraph and not even respond to what she just said there and just meme about. Okay.
However bad you think it is, it's worse.
No.
Remember when Trump's lawyers argued that he could SEAL Team 6 as political rivals, and we all laughed because that's a preposterous thing for anyone to argue, and absolutely no serious person could possibly believe that the Constitution or the laws of this country would allow that to be the rule. Well, the Supreme Court just said, hold my beer while I assassinate my political rivals.
The president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold.
Yes, the Supreme Court has effectively given law-breaking presidents, and we're not singling any one law-breaking president out or anything, could be any felonious president, almost absolute immunity from criminal prosecution. And where the court did not grant outright absolute immunity, it gave presumptive immunity and procedural protections that might as well have been absolute immunity. And while unofficial acts of the president still receive no immunity, the crap cherry on top of this crap sundae is that even though a president now has immunity from criminal prosecution for official acts as president, a prosecutor cannot even use official acts as evidence in a prosecution over unofficial acts, which makes prosecution of some unofficial acts virtually impossible. Whether you are a Republican or a Democrat, this is a terrible decision for democracy. Possibly a top 5 worst Supreme Court decision of all time. Happy July 4th, everyone. But just how bad is it? Well, don't take my word for it. Justice Sotomayor says, quote, the court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The president of the United States is the most powerful person in the country, possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders a Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law,
we've already read all this shit.
Bold and fearless as we would like him to be. That is the majority's message today. Justice Sotomayor concludes that the opinion marked a sea change in the relationship between the people and the president. Quote, in every use of official power, the president is now a king above the law. But how did we get here? Well, until now, executive immunity was a court-created doctrine that shields presidents from most civil lawsuits involving conduct that occurred during their presidential terms. There's no explicit constitutional text granting the president immunity, but in Nixon versus Fitzgerald, the Supreme Court ruled that a president is entitled to absolute immunity from legal liability for civil damages based on his official acts, including acts on the outer perimeter of his duties. The court defined the president's official duties quite broadly to prevent future presidents from being sued for, quote, virtually every allegation that an action was unlawful or was taken for a forbidden purpose. The court explained that it was, quote, settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the president of the United States. To determine whether a particular type of suit against a president or former president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. Indeed, in Clinton versus Jones, the Supreme Court found that under that rubric, the president does not have immunity from civil suits for conduct before they became president. So until now, virtually every lawyer and judge in the country assumed that while executive immunity would shield civil lawsuits because the president could be sued by almost anyone in the country over almost anything, that criminal prosecutions would be different. Why? Because it's way more important that a president be bound by criminal law and not commit heinous criminal acts, even in service of their duties. Plus, there are way more safeguards against criminal prosecution than civil suits. But Trump moved to dismiss his D.C. prosecution on immunity grounds. He lost at the trial court and appealed the decision. Judge Tanya Chutkan stayed the criminal proceedings pending the outcome of the appeal. The D.C. Circuit upheld the lower court's ruling that, quote, former President Trump has become citizen Trump with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. The Circuit Court ruled that presidents are not above the law. Quote, the president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The Circuit Court's decision was widely praised as a well-constructed opinion that came to the only logical conclusion. But then it arrived in the Supreme Court. The top line ruling from the majority of the Supreme Court is this. Presidents cannot be indicted based on conduct for which they are immune from prosecution. Based on the standard that this opinion creates, which we'll talk about in a second, Justice Roberts, writing for the 6th Justice majority, kicked things back down to the trial court. Quote, on remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution. And the parties and the district court must ensure that sufficient allegations support the indictment's charges without such conduct. And the opinion starts with the premise that presidents have lots of power, powers they wield exclusively and do not share with Congress. The court describes the president's core powers as taking care that the laws are faithfully executed, commanding the military and dismissing officers he has appointed, and pardoning people who have committed crimes. So the court created 3 buckets: core official acts, non-core official acts, and unofficial acts. But as you'll see, there's very little difference between the official acts, and very little will qualify as an unofficial act. And the court states, quote, we conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office. At least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. As for his remaining official acts, he's also entitled to immunity. At the current stage of proceedings in this case, however, we need not and do not decide whether that immunity must be absolute or instead whether a presumptive immunity is sufficient. So with respect to the exercise of core powers, the president is apparently absolutely immune from any criminal prosecution related to using those powers. And the court goes on to note that in cases involving Richard Nixon and Aaron Burr, judges recognize that the president has a presumptive privilege to withhold certain papers and communications. Though oddly, in both of those cases, Presidents Nixon and Jefferson were compelled to produce records and recordings because of the public interest in those records was strong enough to...
It's so crazy. This is a part, I can't include every single thing, but like the idea that in those cases, they didn't even get like, there was a balancing test because they were still forced to produce some records. But Roberts just hand waves that and says, well, since criminal stuff is even more severe, then like we'll go even further, again, ignoring the fact that, but there's also greater public interest in seeing those things
overcome the presumptive
prosecuted.
Privilege. However, the court sees the Trump case differently because Trump is the subject of a criminal prosecution. Quote, criminally prosecuting a president for unofficial conduct undoubtedly poses a far greater threat of intrusion on the authority and functions of the executive branch than simply seeking evidence in his possession, as in Burr and Nixon. The danger is akin to, indeed greater than, what led us to recognize absolute immunity from civil damages liability, that the president would be chilled from taking the bold and unhesitating action required of an independent executive. So the argument goes, if a president could face criminal prosecution for his official acts, including communications with his aides, he might be unable to perform his official duties because he fears prosecution. So the court concludes, quote, taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitates at least a presumptive immunity from criminal prosecution for president's acts within the outer perimeter of his official responsibility. Such immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. But what you'll see is that the majority continually only looks to one side. They believe that presidents should be free, but what about the other side? Sure, there are reasons why we want a president to have the ability to take action, but we also have some damn good reasons why we might want the president to hesitate, if not withhold action entirely when it comes to criminal violations. And the majority just simply doesn't address the other side. So the majority sets up a paradigm that first examines whether the conduct involved one of the president's core powers. If it does, the president is absolutely immune from criminal prosecution. If it does not implicate a core power, then the courts have to decide whether the president's acts are official or unofficial. If it's an official act, the president is presumptively immune from prosecution. If it's an unofficial act, then the president is not immune. So how do we determine if the president's action is part of their core responsibilities or not? Well, we don't know. There's no standard in this opinion. They are apparently, according to this court, whatever powers the president has that are not shared with other branches of the government. But it's not like those powers are just listed in the Constitution. And other than the few powers that were explicitly enumerated by this court, including removing people from office and commanding the military, we have no idea what might be considered a core power or not. But even those enumerated core powers are...
There are some things that are enumerated, like pardoning and stuff is enumerated.
...are terrifying, because the court specifically said commanding the military. So if you take one thing away from this video, it's this. Because commanding the military is apparently a core presidential power, and use of core presidential power is absolutely immune from criminal prosecution, any use of the military by the president, including using the American military on American soil, is absolutely immune from criminal prosecution. And if you take two things away, it should be that the president can do anything related to the DOJ, create sham investigations, sham prosecutions, fabricate evidence. They can do any of that, and they are absolutely immune because that's a core function. And a few really good commentators put it this way. The office of the president is like a gun. When you get elected president, you have an unfettered right to use that gun any way that you want to. Your motives and purposes for using that gun are completely irrelevant. You're the president, use the gun however you want. Criminal law does not apply to your use of that gun. And that is why multiple Supreme Court justices are concerned about a president SEAL Team 6ing their political rivals. But some official acts are only presumptively immune. So how would a prosecutor overcome the presumption of immunity that comes with non-core official acts? Well, again, we have no idea. The court doesn't provide a standard. The only thing the court says is that, quote, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. This is barely a limit. There's almost no reason to distinguish between core and non-core official acts if there's no limit on what can be an official act that receives immunity. This language is from the original Fitzgerald balancing test, but turned on its head. Instead of balancing the importance of the intrusion, the court simply says if there's any danger at all of intrusion, there is immunity that attaches to that action. As Justice Sotomayor said in her dissent, quote, no dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes. Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any intrusion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient.
Wait, hold on. Holy shit. I just had a fucking brain blast to fix this entire problem, but probably wouldn't work. When Congress asks for records, or when Congress makes requests for information from people, is that considered like a subpoena? Like when the January 6th committee was doing stuff, is that considered like a subpoena for, is that considered like a subpoena for like criminal purposes, or? Because what I was going to say is, what if the only way to hold the president criminally liable, I'm trying to think if this would work, would be through the impeachment process? Meaning that, let's say that you think that Donald Trump is engaged illegitimately with one of his core powers. So you impeach him, and then in the hearings in the House and the Senate, you make public on the record evidence of him doing wrong things, so that afterwards, if you did want to criminally prosecute him for some other action, you could cite these things on the public record that would have been made public during the impeachment process, rather than citing or investigating or subpoenaing Trump himself. Because one of the things that Roberts said in his decision was, is it this one? It was a stupid comment, but he made it. One of the things that Roberts says in his decision when he's talking about Barrett is, Justice Barrett disagrees, arguing that in a bribery prosecution, for instance, excluding any mention of the official act associated with the bribe would hamstring the prosecution. But, of course, the prosecutor may point to the public record to show that the fact that the president performed the official act. And the prosecutor may admit evidence of what the president allegedly demanded, received, accepted, or agreed to receive or accept in return for being influenced in the performance of the act. What the prosecutor may not do, however, is admit testimony or private records of the president or his advisors probing the official act itself. So what if in the course of like a House impeachment, you do this investigation, but it's not criminal, and then you publish everything from the investigation on the public record, and then a prosecutor only consults the public record when it comes time to, I don't know if this would actually work in practice, but I don't know. All right, sorry.
Hardly matters. Now, I've seen a few legal pundits say that this decision is no big deal because immunity only attaches absolutely for the exercise of core presidential powers, despite the fact that the military is almost certainly core power and lets the president drone strike their rival. But it's okay because other official acts are only presumptively immune and therefore can be prosecuted. But based on this language, that's not the case. Given that the only official acts that can be prosecuted are ones where there is absolutely no danger of intrusion into the authority and functions of the executive branch, that category is vanishingly small. Worse, you can't look to the president's motives to determine whether the act was official or not. Now, even if you're president and you murder your political rivals and receive protection, you'll still want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the legal team. So click below. Okay, sure. But unofficial acts are not immune, right? Well, hold on. First, how would we distinguish a president's official actions from his unofficial ones? Well, the court says, quote, when the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. However, the court then says that official acts are not constrained to the president's constitutional and statutory authority. The majority says, quote, and some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official conduct when not obviously connected to a particular constitutional or statutory provision. For those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. So if you think that sounds like a very broad description of presidential official acts, you'd be right. I would be challenged to come up with a broader definition. But surely plotting to overturn an election result would be manifestly and palpably beyond the president's authority, right? Wrong. The Supreme Court said, quote, in dividing official from unofficial conduct, courts may not inquire into the president's motives. According to Roberts, even asking the question would cripple the executive branch's ability to function. And it gets worse. According to Justice Roberts, quote, nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. So if a president's action violates a law, that doesn't mean he can be prosecuted.
Well, when the president does it, that means that it is not illegal.
As Justice Jackson points out in her dissent, the government will have difficulty proving whether an act is official or unofficial since it can't introduce evidence of the president's motives. That's right, the court says you can't look to the president's motives to determine whether an act is official or unofficial either. You know, for reasons. The only question is whether the president has the power or not. And Justice Jackson points out the problem with this means-only or authority-only approach in her dissent in a footnote. She says, quote, to fully appreciate the oddity of making the criminal immunity determination turn on the character of the president's responsibilities, consider what the majority says is one of the president's conclusive and preclusive prerogatives, the president's power to remove those who wield executive power on his behalf. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority. And the implied answer in that footnote is that the president is free to poison any member of their staff or cabinet because they have authority to remove that person. They've got the power, so any means whatsoever would be an official act. And I'm not being histrionic here. Justice Sotomayor says the majority allows the president to send SEAL Team 6 to kill their political rival. Justice Jackson says the majority allows the president to poison any member of their staff.
I don't understand why, if Sotomayor and Jackson wrote this, and Roberts is writing, countering some of the dissent in his opinion, why does he not address either of those two things?
This isn't just me. These are the dissenting justices on the Supreme Court. This is what I meant when I said this was bad. And this policy argument on which they 100% rely stems from the idea of separation of powers. But it also turns that idea completely on its head because part of separation of powers is checks and balances. And here, they've organized things in a way that the executive is completely unchecked by either of the other branches of government. And while the majority opinion is 43 pages long, it never got around to defining unofficial acts. So while it provides tons of guidance on what is an official act and is therefore immune from prosecution, they give zero guidance whatsoever on what is an unofficial act and therefore would be prosecutable. All we know is that official acts which are immune are anything within the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. That's almost anything a president does. So the court has also made the official versus unofficial distinction almost meaningless. As Justice Sotomayor says, in fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly palpably beyond his authority, he's taking official action. It then goes a step further. In dividing official from unofficial conduct, courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. So to help understand all these distinctions, the great people over at Justice Security put together this great chart. Starting from right to left, if there is official conduct, we have to ask, is it within the core constitutional authority? If it is, there's absolute immunity, no prosecution, and you can't use it as evidence. If it's not core constitutional authority, you have to ask, does it pose any danger of intrusion on the authority and functions of the executive branch? If it does, no prosecution, can't use it as evidence. If it doesn't pose any dangers of intrusion on the authority and functions of the executive branch, then there is no immunity and you can use it as evidence in a prosecution. Then going back up to the top of the chart, if the conduct is 100% unofficial, then yes, you can prosecute it, but remember, you cannot use any official acts or anything that was deemed an official act as evidence in that particular trial. Now, when courts address constitutional questions, they're generally bound by principles of judicial restraint. Now, the consequences of this decision are not just about Trump. It applies to all presidents for the foreseeable future. And that's why it's important to understand the criticisms of this decision and why it's so dangerous. So let's start with one of the court's first big leaps, the idea that immunity shields a president from criminal as well as civil penalties. Why did the majority grant such sweeping immunity? Well, according to the majority, quote, the purpose of a vigorous and energetic executive, the framers thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. They pull that line out of context from Federalist 70, and that's about it. You apparently can't have any enfeeblement whatsoever of the president, even though every president for the last 250 years has assumed that they could be criminally liable for at least some of their conduct. But that's it. That's all the support they have. It's just a policy argument that a vigorous, unencumbered presidency is good, therefore almost full immunity. QED. From proclaimed originalist and textualist, this is honestly shockingly dishonest and hypocritical. Because we're dealing with the Constitution, Congress can't pass a law that says the president will be criminally liable for virtually anything, and the judiciary can't prosecute the president. So the president is unchecked. And the majority opinion doesn't even address the public's interest in not having a criminal president. As Justice Sotomayor points out in her dissent, the court's precedent suggests that presidents do not and should not have broad immunity from criminal law. Quote, at the same time, the public interest in federal criminal prosecution of a former president is vastly greater than the public interest in a private individual civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasize that
nothing in Fitzgerald about the criminal stuff gets cited by Roberts. He only cites to the civil stuff, which is hilarious.
the majority's immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. And the ramifications of declaring the president above criminal law are huge. Justice Jackson explains, quote, put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim, the king can do no wrong, a notion that was firmly rejected at the birth of our republic. And as Justice Sotomayor explains, quote, the majority makes 3 moves that in effect completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text, history, and established understandings of the president's role. Moreover, it is deeply wrong even in its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary hearings is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. The main takeaway of today's decision is that all of a president's official acts, defined without regard to motive or intent, are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptive.
Oh, also, there's a real quick thing. It was kind of a minor point, but I disagreed with this on unofficial or uncivil law yesterday. The Constitution isn't considered federal law, is it? I thought it was, you have like the Constitution, and then from the Constitution you get the judicial, the Supreme Court, the executive, the president, and then the legislature, Congress, and that Congress passes federal laws. But I thought that I didn't think the Constitution was considered a federal law or federal laws. No, like if you pass an amendment, that's not like a federal law. You're amending the Constitution, but it's still something that exists above. Is there like a
cannot touch him. The official acts immunity has no firm grounding in constitutional text, history, or precedent. Indeed, those standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. Now, the 6 conservatives in the majority, all of them self-described strict textualists, were really offended by this comment. They say that, quote, a specific textual basis has not been considered a prerequisite to the recognition of immunity. And Justice Roberts tries to rebut Sotomayor by noting that the Constitution is silent on all matters related to prosecuting ex-presidents. Quote, conspicuously absent is the mention of the fact that since the founding, no president has ever faced criminal charges, let alone for his conduct in office. But that's entirely Sotomayor's point. She says the Constitution...
What would be the distinction? Calling it federal law seems strange because it makes it sound like the Constitution and laws passed by Congress are on the same level, but it's not. The Constitution dictates what Congress can do. Congress cannot pass a federal law that contradicts the Constitution. The Congress could theoretically pass laws that contradict itself or change its own laws or whatever, but it can't contradict the Constitution. The Constitution exists above federal law passed by the legislature.
silence is noteworthy in at least 3 respects. Quote, first, the framers clearly knew how to provide for immunity from prosecution because they did give narrow immunity to legislators via the speech or debate clause. She says, quote, they did not extend the same or similar immunity to presidents. This is classic textual interpretation. If you're bound by the Constitution and the Constitution grants immunity in some places but is silent as to immunity in other places, that immunity doesn't exist. Her second point is that some state constitutions did provide express immunity for sitting governors, but the Constitution did not. Again, calling into question the reason the framers did not extend that privilege to a sitting president. And the third contention was that the impeachment judgment clause cut against the court's position. Quote, that clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. That clause clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery. So there's no other way to put this. This is a horrifying opinion. And I personally worry about the future of this country. For one reason, we can't change this. There's no one to appeal to. Congress can't fix this with legislation.
Nope.
We can't appeal to the courts because the highest court in the land says that the immunity exists and it's almost always absolute. The Constitution is the highest law of the land, and it's effectively like the Supreme Court has amended the Constitution to include an immunity that has never existed before with zero basis in the text and history of the Constitution. All we can do is hope that future presidents won't use this power. This is horrifying not only for those that think former President Trump committed crimes while in office, but for anyone that believes the president should be bound by the law. As of today, for many, many actions, regardless of their inherent criminality, the president is immune. And even if you believed every crazy thing that has been alleged about Biden and the Biden crime family, this decision would immunize almost every allegation that has been levied against him. Of course, the shadow of Trump's actions looms large, but I wouldn't want this opinion to come down during any presidency. Nor does any serious jurist think that this should be the law going forward. No president should.
Could you imagine if Joe Biden was the one that had this court case, and instead of all this Hunter Biden shit, or Hillary Clinton, instead they went and they said, hey, oh, that's actually a good debate point. Hold on. Would you be okay with the entire cases against Joe Biden or Hillary Clinton falling under the purview of official acts in accordance with this ruling, thereby making all of their actions, well, Hillary actually was State Department, I guess. We'll say even if she was president, I'll see what they say. All of their actions absolutely immune from criminal prosecution or judicial review, question mark. Purview spelled incorrectly.
Have this immunity. No president should have this power. And perhaps someday the Supreme Court will scale back this opinion and provide reasonable definitions, but as it stands now, current and future presidents have the powers of a king. So yeah, this is bad, and I frankly can't think of anything worse. And that's also reflected in the news reporting as well. What's interesting is that the Supreme Court decision has been covered extensively by over 400 news outlets, 33% of the reporting coming from the left, and only 17% coming from the right. But if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have a lot of outlets saying that Trump was granted immunity. On the right, outlets tend to draw the distinction between official acts and...
I wonder what Fox News said about this. Fox News Supreme Court immunity ruling.
Oh, sorry, I forgot to tell you something.
What?
Bench is going pretty well. Last session I did 360 for 4 sets of 3. And next session I'm going to do 365 for
Nice.
4 sets of 3. Then after that I'm going to be practicing heavy singles to finally bench 405.
Cool. Well, good luck. Damn.
All right. See you, man.
Have fun. The Constitution versus federal law. Do you think if someone commits treason, the court says you violated the law or the Constitution? Well, treason is one of the few crimes called out in the Constitution. However, I don't know if treason is defined in the Constitution. So you're in one of those like weird worlds. Okay. Same thing with like insurrection. Actually, insurrection is even within federal law, but it's not defined at all in federal law. So it's pretty dumb. Pretty stupid. The U.S. isn't a fully free market economy, but we agree to use non-market means to preserve the market principles in the economy. I think we agree that the U.S. isn't a full democracy either, so why not use less democratic means to preserve the democratic principles of government during a crisis? Because the crisis that you're having isn't that some part of the system is failing, it's that the people don't want it. Like, let's say that there was some issue that was making it so that 5% of the people could vote to elect a president. Well, at that point, it might be okay to use, like, holy shit, we need to sneak into that House of Congress and, like, write a new law, like, secretly, because something is fucked. Obviously, our democracy is not working at that point. If, like, somehow 5% of people are like, right. But that's different than most of the people moving in a different direction. When you talk about, like, the type of economy, it would be like trying to pass reform to make us a capitalist economy if like 50% of the population were all forming co-ops and shit or something. It just doesn't like... Yeah. Okay. Treason in the Constitution is spelled out. Is it though? Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid or comfort. No person shall be... Is that it? Because it's not really a good... There's not much here. It's not much for a criminal statute. I don't think the Constitution does a good job at like spelling out any particular crime.